Okay, Mr. Todd, do you all have anything else to present on behalf of your client?
Yes, Your Honor. My first witness is Mrs. Rump. I would call her. She's out in the waiting room. I would call her as my witness.
Okay, hold on. Who's Miss Rump?
She is a friend of my client's who had direct contact with Mr. Jimenez regarding numerous occasions.
I don't know, Miss.
Okay, hold on, Mr. Jimenez, hush. So here's the question, Mr. Todd, because Miss Rump may have been what you needed for the custody case, but is Miss Rump going to be able to testify as to the contact between her client and Mr. Jimenez? I mean, your
Yes,
client
ma'am.
and Mr. Jimenez?
Yes, ma'am.
And it's not going to be hearsay?
Correct. It's going to be between her and Mr. Jimenez.
Hold on. Miss Rump and Mr. Jimenez.
That is correct.
And contact pertaining to him reaching out to Miss Dorsey.
That is correct.
All right. All right.
Yes,
Yes, Mr. Brooks. Hold on, Mr. Todd.
Before she's allowed to testify, we believe she may be a defendant on an open case. And so I just want to put the court on notice that she's represented by attorney Christopher Walker. And so I don't.
Okay. All right. So I'll make sure she's aware when she comes in.
It's a reckless conduct charge appears to be. I can give you the case number here.
Hold on a second on that.
It's in front of your honor as well.
Oh, wonderful.
She's on your calendar card.
Mr. Todd.
Yes, Your Honor.
And so Ms. Rump, I believe, is a defendant in an open case before me.
Okay.
So, okay, Ms. Rump. So Ms. Rump, you're going to testify under oath, ma'am. I'm going to swear you in and you're going to testify under oath. Understand that you have an open case pending before me that's being prosecuted by Mr. Brooks's office. So please be mindful that you don't want to delve into anything that might jeopardize your defense in that case. You understand that your attorney is not here to represent you.
Yes, ma'am.
And it's my understanding that Mr. Christopher Walker is your attorney.
Yes, ma'am.
You understand that Mr. Todd is not your attorney. He is the attorney for Miss Dorsey.
Yes, ma'am.
All right. And you understand that you're entitled to have your attorney present if you make a statement under oath.
Yes, ma'am.
Okay. So Ms. Rump, are you willing to make a statement under oath without your attorney being present?
Yes, ma'am.
Okay. I'm kind of, all right, Mr. Todd, given that she has the constitutional right against self-incrimination in her case, please be mindful that when you're questioning her, we shouldn't get into anything that involves her case. I don't know if it's related or not. I don't need to know. All right,
Do that.
Ms. Rump, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
All right. Any objections from the state, Ms. Rump? You can put your hand down.
You're not. I guess I'm at a loss because Miss Rump is co-defendants with Miss Dorsey on the case that's coming before the court.
Mr. Todd, that's too close. She can't testify. I won't accept her testimony without her attorney present.
Okay. Give her mother. You have a seat.
Okay, Mr. Todd, who's this?
This is the mother of Mariah Dorsey.
All right, what's her name?
Geraldine Dorsey.
All right, Miss Dorsey, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right. So, Mr. Todd, your witness.
Okay.
Geraldine Dorsey,
Mariah.
my daughter.
So, Mr.
Yes, sir.
Mr. Todd, we can't hear you very clearly, so you
Okay,
need to.
Judge. How about move closer? Okay, Judge. Do you know Mr. Jimenez?
Yes, sir. I saw him several times.
Okay. Has he been over to your house?
Yes, sir.
Okay. And that happened, and there was a bond condition entered in back in January 2021.
Sir.
Okay. That date.
Your Honor, we're having trouble hearing. Could the opposing counsel restate the question?
Yeah, Mr. Todd, every time you lean away from the camera, we can't hear you.
Okay. Anyway, can you hear me now?
Yes.
Yeah, okay. Ms. Dorsey, at any time after January the 2021, did Mr. Jimenez come to your house?
Yes, sir.
Okay. And how many times did he come to your house?
I can't recall how many times, but I know he came over on Mother's Day and bring her flowers.
Okay. He came over to whose house on Mother's Day?
My house and with a plan.
Okay. And did you invite him over?
No, sir.
Okay. And was there other occasions that he came to your house?
Yes, sir.
Okay. So just explain to me when you come over.
Salutes you, Mr. Todd.
I'm sorry, George, I don't know what's. Was there other occasions where he came over to your house?
Yes, sir.
Was there other occasions where he was boisterous, loud, and he?
Your Honor, I apologize to interrupt, but we still can't hear him.
I'm clear, Mr. White. Mr. Todd.
I don't know
Okay.
what's going on. I don't know what's going on with it, Judge. But
Okay.
anyway, I'm going to shift. When I speak, I'm going to shift over. That way I'll speak directly into the mic and then I'll submit it to the witness. Try
Okay.
to see, to hopefully combat that issue.
Okay.
Was there occasions that he came to your house that you had to ask him to leave?
Sir.
Okay. On what occasion? What did he do? When he came over to your house?
He slapped her down. She came upstairs and said he slapped her downstairs and I asked him to leave.
Okay, so Mr. Todd. Mr. Todd. So I'm gonna ask relevance because here's the thing. There's no contact provision on Mr. Jimenez. The no contact provision is on your client. So I get trying to establish that he's made contact with her to mitigate the fact that she's made contact with him in light of the no contact provision. But I mean, like, how deep do I need to go? Do we need to talk about every instance where he came over, where he slapped or didn't slap? I'm not sure that that is helpful to me. Tell me why it's relevant.
Which is relevant because he is contending that somehow, some way, he was afraid, and also that he's testified unequivocally that he's had no contact either in person or by text message after the incident that happened in January. This witness is going to be able to.
Okay, you just muted yourself. Okay, so
Judge.
so I get
So
where you're
Judge,
going.
yeah. So
So-
there's been occasions where not only did he come to the house uninvited, Judge, but also there's been where he has committed physical contact with the defendant in this case, which I understand he doesn't have a no contact order, but obviously he's coming over there at will all the time. And I'm trying to establish the fact that, number one, he's not afraid. Number two, that he's numerous times come over there on numerous occasions. And we're talking about a period of from January, February, all the way up until August of this whole year.
Okay, all right, Mr. Todd. Go ahead.
Okay. Where we left off was, there are occasions where you had to ask him to leave your house.
Yes, sir.
Okay, what happened on those occasions?
Well, when after he hit Mariah, I told him to leave, and I even called his mom and told his mom that the next time he came to my house and behaved in that manner, I was gonna call the police and get him arrested because he's not welcome at my house at all. Yes, sir.
Okay, Mr. Todd, I'm not hearing you. Okay, it works better with Miss Dorsey. So what I think you need to do is like pull back a little bit, pull the computer or the device back away from you, and then move over towards Miss Dorsey so that you all can be in the screen together. Okay, now push it back, push the computer back.
Okay,
There
can you hear
go.
me?
Yes, both of you can speak directly into the microphone and be seen. And you don't have
Okay,
to
fantastic.
bounce back and forth. Miss Dorsey, can you say something for me?
Yes, ma'am.
Okay, thank you. I'm gonna start my new job as a technical director. Go ahead.
Was there occasions where he came over uninvited?
Yes, sir.
Okay, and just tell us what he did when he would come over normally. Would he come over and do what?
He'll come over, he sleep over sometimes, and sometimes he'll come over and they having fussing, they fighting sometimes.
And was this after the bond conditions of January 2021 that he came over to your house?
Yes, he came over, one of the time that I can recall, he came over and he told me that they have AIDS, both of them. I called Mariah, I speak with Mariah, and she said she don't know what he's talking about. I don't know.
Okay, but he did come over on a regular basis?
Yes, sir.
Okay, and did he sleep over and spend the night there?
Yes, sir.
Okay, and this has been after the bond conditions?
Yes, sir.
Okay, and on Mother's Day, what did you observe on Mother's Day?
On Mother's Day, I observed he pulled up and I asked him what he was doing there. He said he bring this plant for Mariah and Kingston, which is his son. And I told him just leave it outside. And she said she didn't want it. She told him she didn't want it. And he said, leave it outside. I tell him leave it outside, and it was outside.
Okay, and did he at any time here after the bond conditions were imposed, did he text you?
No, he haven't texted me. He called me
Okay,
from
so,
a WhatsApp number.
okay, so he's called you on the phone?
Yes, sir.
Okay, and how often would he call you on the phone?
He maybe called me once or twice.
Okay.
Maybe 2 to 3 times.
And what was he, what was he asking you? What was he inquiring about?
Mariah.
Okay, what did he tell
He said
specifically?
he loves Mariah and he wanted to be with her.
Okay, and this is after the bond conditions, correct?
Yes, sir.
Okay. Was there any other occasions
No, sir.
that he came to your house other than what you've already told us?
No, sir.
Okay, do you know whether or not he came to your house when you weren't there? You
No,
know?
I'm not, because I'm a travel nurse. So a lot of time I'm not at home.
Okay,
But for when I'm at home, that's what I can tell you.
okay. All right. That's all the questions I have, Judge.
Cross-examination, Mr. White.
Yes, Your Honor. The defendant is your daughter, correct?
Can you repeat, sir?
The defendant is your daughter, correct?
Yes, she is.
And you love your daughter, correct?
Yes, sir, I do.
Yeah, and you believe your daughter is a good person, correct?
I know she's a good person.
Yeah, and a good person is not capable of committing crimes, correct?
That's correct, but we are all made mistakes. We're humans.
Okay. And you said, Mr. Jimenez here came to your house uninvited. How do you know this?
Because I did not invite him to my house. And as far as I'm concerned, that is my home.
But your daughter invited him, correct?
When my daughter invited him to my home, she'll tell me, Mom, Aaron is coming over. She'll tell me. She'll ask my permission several times too. She'll tell me that he's coming over.
Your Honor, may I have a moment to confer, please?
You may.
Thank you. No further questions, Your Honor.
I just had one.
All right.
Were you there? Were you home? Were you home at any time when Mr. Jimenez came over there to pick up Kingston, the
Yes.
child?
Yes, sir. Sometime I'm the one who she tell me that he was gonna come, and I gave him Kingston. The mom reach out to Mariah, text Mariah and say she want Kingston. So I'll be the one that gave them Kingston a lot of time just to make both of them don't get in contact with each other.
Okay, that's all the questions I have, Judge.
All right. All right. Any recross, Mr. White?
No, Your Honor.
Okay. All right. So I'll excuse this witness. Mr. Todd, do you have any other witnesses to present?
Raise your right hand. You solemnly swear and affirm evidence you're about to give me the truth, the whole truth, and nothing but truth, so help you God?
Yes, sir.
Okay, put your hand
All
down.
right.
State your name.
Hold on, Mr. Todd. Miss Dorsey, so you understand that part of this proceeding is part of the state's decision to prosecute you for the charges of battery, simple battery, family violence, battery, simple battery, family violence, and simple battery.
I'm just not learning that, ma'am.
Okay, so no, let's go back. You were arrested.
Yes, ma'am.
All right, and you were charged with offenses from the charges that you got when you were arrested,
Yes, ma'am.
and you had an arraignment
I
where you
believe-
came to court with your attorney before me.
Oh, yes, ma'am.
Okay, so this is not the first time you've heard about these charges.
No, I thought that this was actually.
Yes or no? And the reason I'm restricting your testimony is because I don't want you to say anything that might get you in further trouble. Okay,
Yes,
so you understand that this is part of the state attempting to prosecute you for the offenses that I've listed.
Yes, ma'am.
And do you understand that anything that you say in this hearing can be used against you in the trial of this case or any further proceedings?
Yes, ma'am.
Okay. And don't tell me what you said, but have you discussed your desire to testify in this hearing with your attorney?
Yes.
And you understand that nobody can force you to testify and nobody can give you anything in exchange for your testimony.
Yes, ma'am.
You have a right to remain silent and not incriminate yourself based on the Constitution of the United States.
Yes,
You
ma'am.
understand? Okay. So at this time, are you waiving your right to remain silent, meaning giving up your right to remain silent in order to testify in this case?
Yes, ma'am.
Okay. All right. So at this time, Mr. Todd, I find that your client is offering her testimony freely and voluntarily. So go ahead. She'll be subject to testimony and cross-examination.
Yes, Your Honor. Please state your name for the record.
Mariah Dorsey.
Ms. Dorsey, do you know Mr. Jimenez?
Yes, sir.
How do you know Mr. Jimenez?
He is my baby father.
Okay, do you have a child born between you and he?
Yes, sir.
What's that child's name?
Kingston Gione Dorsey.
Was that child born with a heart defect and heart problems?
Yes, sir.
Okay, and are you the sole caregiver for that child?
Yes, sir.
Prior to, well, there's been no order entered in this case. Prior to today, there's been no order where he's legitimized the child, correct? Correct?
Yes, sir.
Okay, and prior to this time, he had no legal rights to Kingston, correct?
Yes, sir.
Okay, and just so we're clear, even though he had no rights, did you allow him after the bond conditions, in this case, I'm talking about after January 2021, did you have any contact with Mr. Jimenez?
I didn't understand that question. Can you
Did you have contact with him after the bond conditions were imposed? Did you have contact with him?
I did not make the contact.
Okay.
He came to my house asking for me to come back together with him.
Okay, so who did you go to his house or did he come to your house?
He came to my house.
Who initiated any contact with Mr. Jimenez?
Mr. Jimenez decided to come to my house out of nowhere. He just popped up.
Okay, and did you go over to his house? Did you make the initial contact at any time?
No, sir.
Okay. Tell us, what did he come over to your house for to do?
Came over to the house. He would ask for sex. He would ask for me to come back to him. He would sometimes at first he would just popping up to the house and just parking at the side and just staying there to let him texting me that he's in the area. I would ignore him and he would get upset. There was times where it got to where I had to ask my brothers and my mother to give him Kingston, and a lot of those times he would get upset that he did not physically get to see me, so he would return the child and told me he's not taking him. I also have that in text messages.
Okay, and did he initiate contact with you after the bond conditions?
Yes, sir.
Okay, did he text you?
Yes, sir.
Okay, do you have that on your phone?
Yes, sir.
All right, you can use that to refresh your memory. After the January 2021, tell us about his contact with you. Did he text you after that?
January 2021.
After that, you have.
Okay, after January 2021, he did make contact with me. He was trying to come over. He was sleep over. November of 2021 was actually my daughter's birthday month. He had that day, that week, same thing. I was telling him I didn't want to see him, didn't want to talk to him. He came over the house, and his intent was to sleep over and have sex. After him leaving, he didn't take Kingston. It was just, he just was there trying to see me, told me that he wants to get married and he wants us to move in together and things like that. And he's sorry that he ruined the relationship with me and his family because of he was absent in the beginning.
Okay, so who initiated that? You contact?
Yes, sir.
Okay. Something happened on Mother's Day, as an example. What happened on Mother's Day of this year after the bond conditions?
Mother's Day, I was actually out with my friend. I got a text message that I'm in the area. I want to see you. I just so happened to pass by the house just to see how is he's waiting for me, how is he trying to see me. Pass by the house, it's his mom's car. He's sitting outside of his mom's car. I drove straight past. We just went to go get some things from Walmart and chill at her house and watch TV and stuff. And I just talked about it. I was like, I don't feel comfortable. It's been like over 5 years, 7 years now. He hasn't really trying to do much. I'm just like, I didn't feel okay with going to the house with him being there. I knew of the flowers. I didn't take the flowers because with all the recordings that he was doing of me, where he was just constantly trying to find just anything just to use as blackmail if I left him or anything, including my son. I didn't take the flowers because I thought honestly there was possibly a mic or a camera in it. So I left it outside.
After these bond conditions were put in place, did you initiate, in other words, did you make the move to contact him?
No, sir.
Okay. Any contacts that were made, did he initiate, start them?
Yes, sir.
Okay. As far as texting was concerned, did he text you after the bond conditions were in place?
He texted me. I blocked every single account that he made. He made a fake one. He had also his other girlfriend that he knew way before me decided to contact me, which is Diara. She decided to contact me asking if she could also see my son. They want him. They wanted to form a relationship with me too. And I did not respond. And she just been making random more accounts. And I had distressed to her, that I wanted her to leave me alone. If she's with him, please enjoy him. So can Jasmine. I'm just here for my son. I'm trying to finish school. My cousin recently died. I'm trying to be there for my family the entire time. And I just didn't want anything to do with it. I just blocked every single account.
He persists, even though you blocked his account. Did he persist in trying to contact you after that?
Yes, sir. He contacted my friends and then was trying to find out what my whereabouts were.
Did you at any time initiate this contact? Did you make the first move?
No, sir.
Okay. I think you mentioned it, but did he come over to your house and actually spend the night over there?
Yes, sir.
Did you initiate that or did he initiate that?
He initiated it because of this case going on my hands is in a lion's mouth. I don't want to do anything to tick him off anymore. Because the ball is in his court. He could do whatever he wants with me at that point. So therefore, I just feel like I'm hopeless.
Okay. Did you at any time threaten him?
No, sir.
Text messages or whatever saying that. Did he accuse you of threatening him?
Because anywhere in his, I don't understand. I can't read.
Okay, did he at any time tell you that he felt threatened by you?
Never told me he was threatened. He was just trying to stay over my house, ask me why I was acting different. He didn't like the fact that I wasn't comfortable with him all the time. Like I wasn't like being more relaxed and acting bubbly how I normally would. So he was upset about it. So he just was, one thing led to the next. He told me he was gonna kill himself, all other things. He's mad about the fact that he can't bring me to his house. His family now doesn't like me because of what he did and stuff like that. But that's behind us. It's time to heal.
Did you intentionally violate the bond conditions? In other words, did you contact him to violate the bond conditions?
No, sir. After I came out of jail, I was ready to at least go back working and trying to make some money for my kid, because I took the months before that I was in the hospital with my son, couldn't work because I'm trying to find out if my son was going to make it out alive or what's going to happen next. So I wasn't even able to work from that point. I went to go work straight after that to make some money up. My people had to get me out of jail. I had to help pay the bills and stuff like that. So my number one goal was taking care of my kids and maintaining my home.
Is that what you did?
Yes, sir.
In some testimony here, did you at any point damage his vehicle?
No, sir. I never damaged his vehicles for even when I was pregnant with his child, and he ghosted us, wouldn't talk to us or anything, and never would damage anything of his stuff from even years before, from 2015. No matter what the circumstances were, I knew, take everything with a grain of salt and just move on. Just focus on yourself, make everything happy for you. I continue to occupy myself with going to school, educate myself so that I could be a better person.
Okay, and were you aware of, was his car, to your knowledge, ever had gunshots before?
There was a time he was supposed to pick up Kingston, and he showed me that he was at a Red Roof Inn when we was like videoing, and he was like telling me
Objection, Your Honor, lack of personal knowledge, hearsay.
no.
Mr. Todd, I can't hear you so well, so
Well,
can you?
I'm sorry. I said she's testifying as to what Mr. Jimenez told her.
We was on FaceTime.
Yes, ma'am.
Your Honor, if I may respond, Mr. Jimenez is not a part of the state. The state is the party.
He's a witness that's testified, Judge, and he's testified. He's already testified, so she can testify to personal contact and what he's told her. I mean,
Okay, hold on. Mr. Todd, I see where you're going. I'm gonna give you a little leeway. I'm gonna overrule the objection, but I just really like make the point, move on.
okay. Did he tell you that his car had been damaged before?
Yes, sir. He had a lot of enemies out on the street. I know one time he showed me that he was out at Red Roof Inn. He told me he will be out soon. I didn't know what it was, but I felt like he wanted to go meet a girl. I guess it was possibly
Ms. Dorsey, focus. Was the
okay.
car damaged or not? Tell me
The
about the
car
damage.
he showed
I
me
wanna
it
hear
was
anything
damaged.
else about another woman.
Okay, he showed me it was damaged. I didn't know if it was gunshot for sure, but I saw the windows were broken. His wallets were missing. He said that he lost money. So I know that morning he called me from the night to the morning. He's still at that hotel. So that's what got me to thinking maybe it was something personal.
Other people, and when I say that is other people, his girlfriend tried to contact you?
Yes, sir.
Okay. Told him, no, you don't want to have any contact with them?
I just blocked them. And I
Okay.
one of them, for instance, I did tell them, please leave me alone.
That's all the questions I had, Judge.
That's all, Your Honor.
All right, Mr. Todd.
Yeah, sure. That's all the questions I have at this point.
All right, Mr. White, cross-examination.
Yes, Your Honor. Ms. Dorsey, earlier on direct examination, you said you've never initiated contact with Mr. Jimenez. Isn't that correct?
Yes, sir.
Okay. And you were here when I talked to Mr. Jimenez during his direct examination, weren't you?
Yes, sir.
Okay. Your Honor, permission to publish Exhibit 1?
It's admitted, so publish it.
Oh,
All right.
I couldn't hear what he said. I couldn't hear what he said.
He asked for permission to publish Exhibit 1. It's in the,
Oh.
it's admitted, so he can publish it.
Oh,
States Exhibit 1, Your Honor.
I got you, sir.
Yeah. Mr. Jimenez, referring to States Exhibit 1, on June 27th of 2020, you messaged Mr. Jimenez, Daddy, come get our love child, didn't you?
Judge,
No, sir.
Judge, he's talking about 2020. That's before the incident even happened.
Yeah, I did.
Okay.
Okay. Your Honor, on June 27th of 2022, as published into evidence, the defendant messaged Mr. Jimenez, Daddy, come get our love child. The defendant messaged Mr. Jimenez, she stays in a one-story house. The defendant messaged Mr. Jimenez, you got 3 days. After responding to Mr. Jimenez's request to
Objection, Your Honor. Is he asking a question? Is he?
Yeah,
going-
Mr.
He's making
White.
a statement. He's making a
Okay,
statement.
so
here.
Mr. White, generally when you ask to publish something, you show it to us.
Okay. Here is the beginning of the conversation, Your Honor.
Your Honor, because of the difficulties of digital testimony, the state elected to publish by reading it into the record. And Mr. White was going to read it verbatim as it's written on, as it came through the text message. So in green would be one person and then the response and then back and forward. He obviously can hold it in front of the camera, but the text is so small that the court won't be able to make it out, I'm sure.
Okay, and y'all can't scan and share?
Because we haven't seen it, Judge, obviously.
All right, Mr. Todd, I'm trying to,
I figured since it was already in evidence, I thought it was already scanned and
if it's scanned already, then he can share it.
and Your Honor, forgive me, I was not in the room when
I got you, Mr.
when the tender, but
We're
He tended
scanning right now.
on the paper, but that I believe was because it hadn't been admitted yet. But if you want to publish it, we can have it scanned and share it. That would help. Because Mr. Todd and I haven't had an opportunity to read it.
we about to email to you right now.
figure. Thank you.
Are we talking?
Well, no.
Is he talking?
Mr. White, you're muted.
Your Honor, we are published the evidence on the screen, exhibit 1. I'm not. I can't.
Okay. Scroll down to the bottom. Okay.
Could be Liara. It could be the other girl. Cause he with this other girl too. So she
All
got
right,
two kids.
Ms. Dorsey, hush.
Oh, I thought I was on mute.
Yeah, off of mute.
All right, Mr. White, I've seen it. I read it. Okay. You're on mute.
I apologize, Your Honor. Ms. Dorsey, on June 27th, you messaged Mr. Hernandez, Daddy, come get our love child, didn't you?
No, sir.
So you didn't text him any of the messages published in Exhibit 1?
No, sir.
Your Honor, may I have a moment to confer?
Okay, Mr. White, but confer about everything you need to confer about and anticipate some things because it's almost 8 o'clock.
I apologize, Your Honor. This is the last time. Ms. Dorsey, earlier on direct examination, you said that you never wanted Mr. Jimenez to come to your house, right?
Yes, sir.
That you didn't want him to spend the night.
Yes, sir.
So you never wanted any sexual relations with Mr. Jimenez.
Yes, sir.
So you didn't send a message telling him to come over in Exhibit 1.
And I said a what, sir?
You didn't send a message that you wanted him to nut in your pussy in Exhibit 1.
No, sir.
No further questions, Your Honor.
Can you hear me, Anna?
I hear you.
Okay. Dorsey, on this text message that they showed, there's a telephone number on there. Is that your number?
No, sir.
Did you send this text message here that they've shown to you Did you send that to him?
No, sir.
Has he, that is Mr. Jimenez, sent you messages with fake phone numbers and fake information on it?
Yes, sir.
That's all the question.
All right.
That's all, that's all the evidence that we have, Your Honor.
Alrighty. All right, so Mr. Todd, your side is rested. State doesn't have any more witnesses, only argument. All right, I'll hear from you all now.
Thank you, Your Honor. You want me to go first?
You may.
Okay. If it pleases the court, Your Honor, this is the state's motion in this particular case to, I guess, either modify the bond or do something with the bond in this case. Obviously, it's a serious situation because of the fact that they want to somehow take the liberty of my client away. I would submit to the court, based upon the totality of evidence that has been presented in this case, that this gentleman has contrived the situation that started back in January, Judge, in this case, and it's gone now for however long it's gone. He never legitimized the child, never had any legal rights to the child in this case, did not pay child support, nor did he have any legal rights. My client, the parties got together. They were trying to work it out between themselves. Unfortunately, they had spats back and forth, but there's no evidence that my client, as she just testified to, unrefuted, that whatever they've just presented to the court was not her telephone number, was not her text number, that she did not text it to him. There's no evidence to the contrary. It's uncontroverted. He has no way of knowing. It came from a number, an unknown number. He did not testify it was from her number. So therefore, Judge, you have the situation here. I believe at the very least you have is a conflict in the evidence. The state has the burden of proof in this case. Judge, they haven't even carried the burden. But even if you want to go to the lowest, Judge, there's definitely a big conflict in the evidence in this case. Bear in mind what we have here, Judge, is the fact that this gentleman, who had no legal rights to the child, had not legitimized the child. Now, after this, he files a legitimation case, Judge. And so therefore, a lot of this stuff is contrived from the fact of he has done or tried to do whatever he could to obviously make my client look bad, but more importantly, to somehow get her bond revoked in this particular case, or modified, or whatever the case may be, when it's clear that he was the person that made the initial contact. Yes, my client was not supposed to have any contact, but you have a situation here that he continually wanted to get back with her, wanted to have a family, wanted to be part of the family, that he's the one that was the aggressor and made the contact and gone over to her house, went to her house. Testimony has been that he's been the one that's been the aggressor, and he's the one that has continued to make the advances towards my client. So even though, yes, she was not supposed to have any contact with him, but he continued and continued to force himself on her to the standpoint of going over there to get the child, to visit with the child. And my client even allowed the child to go, even though she had no legal reason or legal obligation, allowed the child, as testified from them, to stay over there with the parent, with him and his parents, or his parent, is for the visitation and so forth. So anyway, Judge, it was all as a result of this lawsuit. We had the civil case. And the reason I bring that up is because this was all to build up a case to try to get the civil case for him to try to get custody. That's what he was trying to do, even in this situation, going back before this, trying to get custody. That's what he was trying to do. It didn't work. It failed. We say based upon the evidence. Judge, you've heard it. You're smart enough, Judge. I don't need to say any more. Obviously, there's not enough evidence here to revoke my client's bond and take her liberty away based on what Your Honor has heard in this case. Thank you, Your Honor.
Mr. White?
Yes, Your Honor. Your Honor, this case is a bond revocation case. It's not about legitimizing a child. It is not about who won custody. It is a bond revocation case. And the terms of her bond was to have no contact with Mr. Jimenez. And the proof has shown that she violated that no contact multiple times. Now, the defense is trying to bring forth, she didn't initiate the contact. She didn't initiate the contact. But you heard from Mr. Jimenez what happened. He didn't initiate, he only responded. You saw the text message exchange between the two parties of her initiating contact with her, of him asking her, if you want contact, let's meet at the police department. She wouldn't have it. She continued to threaten him with countdowns. You have 3 days. You have 2 days. She made threatening contacts to him, provoking contacts to him. Furthermore, Your Honor, the state has brought forth a witness in her mom to testify that Mr. Jimenez initiated all contact, but her mother said that she did not allow Mr. Jimenez in. The mother herself, she never said her daughter didn't allow him. Everything she knows about the situation, she was told about from her daughter, who she loved, who she said was a good person, who she said would never commit a crime. But we know that's simply not true. We know that she's committed multiple. And then finally, going on to this child revocation situation, the defense keeps on bringing it up, that happened 2 days ago. Mr. Jimenez filed a police report in June, long before 2 days ago. He came to the solicitor's office for an affidavit in July, long before 2 days ago. So when we look at the fact that this is actually a bond revocation hearing, and that she violated the terms of her bond by contacting him, initiating contact with him, that enough should be suffice to revoke her bond. But furthermore, Your Honor, when looking at the Ayala factors, this defendant poses a significant risk of intimidating the witness because she has already reached out to the victim, the witness, and threatened him. And furthermore, she's also a risk to reoffend as she has already violated her bond order of no contact with the victim multiple times. And because of this, Your Honor, the state asks you to revoke the defendant's bond.
Okay. All right. So one of the most serious things that I get asked to do is to revoke someone's bond, because pre-trial detention is for the purpose of establishing that this person is going to appear for court, and then the public policy and the Constitution, the statutes, they all lean to pre-trial detention not being prolonged beyond the point where we are assured that the person is going to show up for their hearing or whatever court proceedings are there, and they're also not going to pose a danger to the community. And so when someone brings evidence to me that states that someone has violated a court order that is imposed to keep the peace between parties, then I take that very seriously. The issue that I have is that Exhibit 1 was admitted, but technology being what it is, Ms. Dorsey has denied that that is her, and Mr. Jimenez's testimony is not enough to sufficient to establish that the phone number on that on those text messages actually did come from Ms. Dorsey. The other issue is that these parties have had enough contact since January 7th of 2021 that the court is not, I mean, prior even to the June 27th through 29th situation, there was contact back and forth. They freely exchanged the child. They went back and forth with each other. Both sides have credibility issues in light of the court. And so the problem that I have is not that I think Ms. Dorsey is a danger to Mr. Jimenez, but I think they might be a danger to each other and the child. I seriously have an issue at this point where I wish I was still on magistrate court, where I could impose restraining orders that keep both of them from having contact with each other, because I think Mr. Jimenez is just as dangerous in this situation as Ms. Dorsey. I think that they are both somewhat obsessed with each other. I think that this situation has gone on for quite some time. I think that both of them are individuals who need to mature substantially. and don't understand that a co-parenting relationship does not involve threats, does not involve over-sexualized language, does not involve showing up at somebody's house, does not involve getting involved with the other person's other parties. It is just ridiculous. Just the amount of information I've heard, which I know doesn't come close to what was argued in the custody case, but you both are not showing that y'all are ready to be parents. This is horrific. Mr. Jimenez, if you wanted to have contact, you know that there are charges pending in which you are the complaining witness against Miss Dorsey, but you continue to have contact knowing that there was a no contact provision. And even though the court has not established jurisdiction over you in this case, you're the one stating that she victimized you. Instead of going to the court and establishing a way through the courts to see your son or to legitimize your son, you just kept going to see them without any regard to the fact that there was a no contact provision in this case. Ms. Dorsey, you also know that there's a no contact provision in this case. And as I often tell people when they come before me for arraignment, and I'm pretty sure I told you this, if you are contacted by the other person, then you are to keep a record of it, but you are not to respond. Keep a record of it, but don't respond, because you're the person who, if it results in contact being made, you're the person who faces having your liberty taken away and you being put back in jail. And you can also be charged with a misdemeanor or a felony punishable by more than by 10 years in prison, a $10,000 fine, or both. I know the speech. I can say it off the top of my head. If you woke me up in the middle of the night, I could say it. So I know I told you. But you two are acting like there's no. All right. So in the middle of what was probably a perfect rant, the kid cutoff time got me. I was on the wrong network. So here we go. At this point, I am really just, I just don't know what to say. I've heard evidence and testimony. Is the state there? Because I see a black screen. I need to see the state.
Your
All right.
Honor,
So
we're under Charles Brooks.
I've heard.
I was just trying to say that we were here.
Yeah, we're back. So I've heard evidence and testimony from both sides. I am disappointed deeply in both sides. I wish I could impose a no contact provision for both sides, Mr. Jimenez not to have any contact, but this is what I want to let you all know. One, I don't find this, is the state frozen? Somebody wave.
No, Your Honor.
Okay.
Can you see this?
So one, I don't find that there's sufficient evidence to revoke Ms. Dorsey's bond, because there's been no evidence that assures me, with in light of technology, spoofing, and the animosity between these two parties, that those messages were actually sent from her. Number one. Number two, there's been more than enough evidence that Mr. Jimenez, even on his own testimony, has spoken about contact he's made with her, using the child as an excuse to make the contact, but making the contact nevertheless. So Mr. Jimenez has not evidenced to me that he was afraid for his life or safety in light of charges that are existing against Miss Dorsey. I just can't tell you how y'all just really don't understand how crazy y'all look. Really don't understand that I'm afraid that there's a child that has to grow up in this atmosphere. Really don't understand that neither of you are going to make mother or father of the year. How you really don't understand that it is bigger than both of you, and y'all are playing out these little petty issues that y'all have with each other. And the criminal justice system is going to do what it does, but y'all haven't come to the realization that y'all have to grow up. you have to respect each other as the parents of the same child. And if the court imposes an order that there's to be no contact, then y'all are to listen to that order. Now, this is what's going to happen. I'm not revoking the bond at this time, but Ms. Dorsey, please understand, should there be competent evidence sufficient to convince me that you are in fact having contact with Ms. Jimenez, then I will put you in jail until such time as this case is concluded. And so understand, my understanding from the testimony is that you have more than one child, and I'm sure your mama as a traveling nurse doesn't want to babysit your children, so be mindful of that. Mr. Jimenez, please understand that the court will not take it lightly if you have contact with Ms. Dorsey of any kind. Anything that is not through an attorney or the courts is going to be frowned upon strongly by the court. Are we clear? Y'all seem to be frozen. So if anybody's hearing me, let me know.
Yes.
Because I don't understand how y'all don't understand how this makes you look. Ms. Dorsey, you got a lot to lose. You got stuff on the line. You got 4 counts against you, and with murder being considered, ma'am, you looking at some serious charges and some serious time if you were convicted. Keep that in mind. Mr. Jimenez, you can always be charged with something if your contact gets out of line. Your conduct gets out of line. I cannot believe what I've heard here today from 2 people who call themselves parents. Young, but at the point that you have the children, you got to grow up, both of you. And Mr. Jimenez, really, your conduct is scaring me a little bit. Because if any of this is true about you just showing up at her house, lurking around her doorstep, dropping off flowers to your baby mama when she didn't ask for them, that's scary to me. That's stalkerish. So at this time, this hearing is concluded. I am not going to issue a bond revocation. Mr. Todd, based on the principles of fundamental fairness, you can present a proposed order that denies the state's motion for a bond revocation in this case. You can be as simple as that. Everything else I've said is on the record. And at this time, this hearing is adjourned.
Thank you, Your Honor.
Yes, Your Honor.
Order to the court with a copy to the district.
Yeah, you can just go ahead and
I will do
see,
that.
just copy the other side and send it to through Miss Val until my new